Hey, do you want to build a stronger family, create a better life? Well, that's what Divorce with Heart is all about. It's a show where I guide you along your divorce and co-parenting journey using the heart's wisdom, intuition, and legal expertise. So sit back, take a deep breath, relax. My name is Gina DiPrima. Let's get started. Hello, how's everybody? Welcome. This is Divorce with Heart, and I'm your host, Gina DiPrima. Today is our 37th episode, and today, and also the second episode that I'm doing here, because now I'm down to two shows a month, but I'm trying to focus them around a similar theme, so kind of trying to keep it together a little bit for you. So today, and for the next episode, we're going to be talking about communication, and that's our March theme here. It's all about communication. And the focus for this show is going to be communicating with the attorney for the child, which may also be the guardian ad litem or maybe the law guardian, depending on where you're at in the world, or the attorney ad litem. There's different names, and there's some distinctions in terms of the person's role and how they play out in your divorce or your custody case. And I want to dive into that further today, and how you can best, represent yourself and your case and your children when you're talking to the person in this role. Also, along those lines is a custodial evaluator. And I'm sure they're known by other names depending on your jurisdiction as well. But I think for that, there's less of a distinction there. Maybe just a slight tweak in the name of what they're called. But once I get into what the person's role is, I think you'll know exactly what I'm talking about. But again, we're going to keep the focus today for today's conversation on communicating with these different people and how you can prepare yourself for the most success and for the best outcomes, especially when it comes to you and interacting and communicating with these people. So that's what we're going to do today. And before I get into that, though, I have something very exciting to announce. I've been saying that I wanted to start drawing a winner monthly at random based on the reviews that come through iTunes. And I have to say this too, because there might be some confusion here. A rating is not the same as a review. A rating is where you can click, however many stars you want to give the show. And I think it's between 1 and 5. And a review is where you can actually leave a comment. I don't know. I have no way to access who leaves ratings. So I can't, if you're leaving just a rating, a star review, I appreciate it. I do. I appreciate it so much. And I love you for it. But I can't include your name in this monthly drawing for the giveaway. So I have to only look at the people that are actually leaving comments and those kind of reviews in iTunes, because those are the ones that come to me. So the winner that I picked goes by, or at least the screen name on the comment was JD15639. JD15639, who commented that the show is a must listen for anyone looking for help with difficult relationships. So thank you so much, JD15639. Oh, it's a mouthful. I appreciate you listening, and I hope that you're finding the show helpful and that you've been able to share it with others that you may or may not know that are going through difficult relationships. And please reach out to me if you're a member of the Facebook group. Reach out to me there through Facebook Messenger, or send me a text message, 716-388-4085, so I can hook you up with your gift. And also in the future, I think it would be super helpful for me if when you leave the rating, if you want to be included in the monthly drawing, if you can actually take a screenshot of your review first and get that to me either by Facebook Messenger or text message or even email at divorcewhart@dprimalaw.com. So that way, I can be sure to authenticate whoever the person is. Not that I would suspect that we'd have any issues there. So anyhow, thank you so much. Thank you for playing along. Thank you for your review, JD15639, and can't wait to connect with you further to gift you my appreciation. All right, so let's go at it. First, let's focus on the whole attorney for the child, law guardian, guardian ad litem, attorney ad litem, and what does all of that mean? Right? Like, who are these people? What do they mean? What are their roles? And it's so important because inevitably you're probably faced with having to deal with somebody in one of these functions while you're going through the court process, whether it's divorce, custody, visitation or access, anything having to do with children. You're probably facing the idea of having one of these people involved with your case. Okay, I know in New York, it's pretty much mandatory now. And I think that a lot of the jurisdictions are doing the same. So there's no way around it. And your ability to really understand the person's role and where they're coming from, I think can really help to alleviate some unnecessary stress and the frustration and, all of the extra stress that you might be experiencing while you go through this. Because I know that for a lot of you out there, dealing with the law guardian, dealing with the attorney for the child, it causes this extra layer of frustration. And I think a lot of that stems from the fact of not really understanding that person's role or confusing that person's role with maybe the role of your attorney or the job your attorney should be doing, or the job of the fact finder, which may be the judge, it may be the referee. Again, I think the names change depending on where you are in the world, but the functions in that respect are pretty much the same. And I know that this is the case, that it causes a lot of grief for people because, I am an attorney for the child. I am appointed by the courts. I act in this capacity regularly. I've been doing it for, almost 2 decades, I think now. Originally, I was a law guardian. The roles changed here in New York, and I'll discuss that. But, long and short, I know what it's like from being that person in that role. I know what it's like to feel the frustration that a parent has when they don't understand, what I, as the AFC or as a law guardian, am doing. And when they feel that I may be falling short. And when I'm saying I do mean it more in a generic, categorical kind of a way, because that's what these complaints are. And it stems from a misunderstanding, I think, a lot of times, on what the actual role is. And so if you can understand that, that's, your first step in the right direction. So first, law guardian, attorney for the child. In New York, we were always called law guardians for a long time. And that changed several years ago. And when that changed and the title changed to attorney for the child, the role also changed. And a guardian ad litem is not the same as an attorney for the child, but is probably closer to the definition of what a law guardian is, or what we used to be here in New York as law guardians. So let's start there with the whole law guardian ad litem concept. This is a person that is appointed by the court most often to really promote and or protect your children's best interests to the court and through the process. Okay. They may or may not be an attorney. They don't have to be an attorney. I know, especially in a lot of other jurisdictions, these roles are filled by social workers and people that have more of a mental health background. Sometimes they're volunteers, sometimes they're not. But the point is that they may or may not be an attorney, but when they're acting in this role as a guardian ad litem or a law guardian, they are not acting as an attorney. Okay, they are acting as more of a protector of the child's best interests and a promoter of the child's best interest. And you can contrast that then with what an attorney for the child is, or an attorney ad litem, as they're called in other jurisdictions. And that's what we have now in New York, is attorney for the child. And it is exactly that, attorney. Attorneys for the child, attorney ad litems are attorneys. And their role is not to protect or promote the child's best interest, which is a widespread mistaken belief, not just by people going through the process, but I'll tell you, even by other people on the bench in the bar, as we call it. But as an attorney in this role, their job is to advocate for their client's needs, their client's desires, their client's wants. And who is their client? Their client is the child. So just like when you, as a parent, as a mother, as a father, as a husband, as a wife, just like you have your lawyer that you meet with and you bare your soul to, that you strategize your case with, that you talk about the pros and cons of your position with, that you do all of that stuff, in order to try to advance your position or come up with an agreement, just like you have that person, that's what the attorney for the child or the attorney ad litem is to your child. So their role, and this is a very important distinction, is to promote what it is that your child wants, what it is that your child desires, what it is that your child needs. And that may or may not be the same as what is in your child's best interest. You see, as a law guardian or a guardian ad litem, as I stated before, their primary role is to promote and advocate for the child's best interest. Different and apart from what the child wants. So I hope that this distinction, it's a very, very important distinction, and I hope that it's making sense as I'm saying this. In New York, it's not like, we're oblivious to the fact that children don't always understand what's going on or what they're thinking or the ramifications of what they want and what their desires are. And, our statutes, our legislatures have dealt with that by leaving the door open for attorneys for the children to substitute their own judgment, their own personal judgment for what they believe to be in the child's best interest under limited circumstances. So what that means is if a child, for example, this is the easiest example. If a child is too young to really speak for themselves, too young to really grasp the concept of divorce and mom and dad living separate and apart, too young to really understand what that's going to mean for the child in their day-to-day life, then, of course, the attorney for the child, the attorney ad litem, is not restricted or forced to advocate what the child wants, especially at a certain age. Babies even, they can't even tell you what they want, right? So then that would be a perfect example of when an attorney for the child or an attorney ad litem can substitute their own judgment for what they believe to be in the child's best interest. Okay, so age is a factor that allows an attorney for the child or an attorney ad litem to, deviate from what their client might be telling them and instead advocate for something that they think is in the child's best interest. Age is one of those circumstances. Basically, to summarize it all, it's if the child does not have the capacity for knowing voluntary, considered judgment, to really grasp what's happening, then it might be possible for the attorney for the child to substitute and act in a way that is to promote and preserve the child's best interests rather than what the child says they want. Okay. Another example is if the child is wanting something that is clearly detrimental and would cause imminent harm to the child. Imminent harm. And this is not something that's just for an opinion or speculation or judgment. I mean, there's a lot that goes into this, and I'm just trying to keep it kind of on the surface and summarize. But if that's the case, then the attorney for the child may be able to step aside from what the child is saying they want and instead advocate for, talk to the judge about, build their case around what they believe to be best for the child. All right? Now, a law guardian and a guardian ad litem, like I said, is not an attorney. Their role is very, very, very different than that. They are really charged with or responsible for, like I said, promoting what they think is best for the child. So in both cases, if you're under the umbrella of a law guardian and a guardian ad litem, we'll call that like umbrella one, I guess. If you're under the umbrella of a attorney for the child, attorney ad litem umbrella two, in both cases, the person is going to be interviewing the children, going to be interviewing your child. In both cases, that interview is to be a private interview, okay? In both cases, the person is of the ability and the capacity to investigate facts of the case, investigate circumstances of the case, talk to collateral sources, talk to other witnesses, review school records, review medical records, review Child Protective Services records. I mean, whatever it is that is coming up as having to do with your separation or is having to do with the child and the child's future and the relationship with either parent is something that could be subject of an investigation, whether it's the law guardian, guardian ad litem, or, as I said before, an attorney. So expect that this person will be, or at least should be, as part of their role, investigating what's going on. If for nothing else, to help them to understand, at least if you're an attorney for the child, the child's position, to understand if what the child is saying comes from a place of knowing, voluntary, considered judgment, okay? And so in both situations, as I was saying, there will likely be an investigation. There will likely be interviews. There will likely be the review of documents. What happens when you're a law guardian or a guardian ad litem, you're often requested by the courts, because again, in both cases, the person is appointed by the courts, by the judge, by the referee. But what happens is a law guardian, guardian ad litem, you are often asked to prepare a report to the court that basically summarizes your work, summarizes your evaluation, and makes a recommendation based upon your recommendation, your interviews, your review of documents, that makes a recommendation upon what you think is best for the child. What kind of parenting schedule is best for the child? What kind of custodial relationship is best for the child? Things like that. So they make this recommendation. An attorney for the child, an attorney ad litem, does not prepare a report and make a recommendation because, again, they are there as a third attorney. They are there advocating a position, which is the position of your child. So, if your child wants to wake up every morning and eat chocolate cake for breakfast, that might be their position. I mean, obviously, that's not what it's going to be, but I just want to drive the point home that just like when you meet with your lawyer and you have your position, it might be totally irrational. It might be a position that your lawyer doesn't agree with, and hopefully your lawyer is going to work through that with you. Hopefully your lawyer is going to have a conversation with you about it, all the pros and cons, and strategize. And the same should be happening with the attorney for the child when the attorney for the child meets with the child. But at the end of the day, attorneys' jobs are to zealously advocate for their clients and their client's position. All right? So those are huge distinctions between these different roles. And if you can grasp that, then I think that that's really half of your battle there. Let's see. So in all cases, whether you're dealing with a law guardian, a guardian ad litem, an attorney for the child, or an attorney ad litem, in all cases, you should talk about it first with your attorney. Talk about it first with your attorney. Make sure your attorney is giving consent for you to talk to these people without your attorney present, especially if it's an attorney for the child or an attorney ad litem, because again, they're attorneys and their position might be aligned with yours. It might not be aligned with yours. But either way, they're taking a position at trial and they're going to be questioning witnesses, cross-examining witnesses. They have their own theory, their own agenda. So naturally, you're going to want to know from your lawyer if it's okay for you to talk to that person. What kinds of things should you share? Should you not share? That sort of conversation needs to happen. And if your lawyer agrees, if your attorney gives you permission and consent to meet with this person without your attorney being there, then great. But don't just assume that that also extends to you sharing your documents, your calendars, your notes, your text messages, your emails. Don't make that assumption. Be very, very, very clear when you're talking to your own lawyer with regard to what information you can share and what information you shouldn't. Because I'll tell you, especially from my point of view in my practice, if I even give my clients consent to speak with another attorney when I'm not there, I tell them that I need copies of everything. I want copies of every text, every email, every journal entry, every calendar entry, whatever it is that they're going to be providing to another attorney. I want to lay my own eyes on it first because I need to know exactly what it is. And it's also rare that I allow my clients to speak with another attorney without me present for the same reason. I want to know what my client's saying. So this is a conversation that you absolutely need to have with your own lawyer before you engage in any conversation at all with any law guardian, guardian ad litem, attorney for the children, or attorney ad litem. You need to have that conversation, okay? And same thing, I didn't really get into the custodial evaluator. Let me just touch on that quick. Same thing if you are having to meet with a custodial evaluator. A custodial evaluator is not acting in the case as an attorney, but they are hired to act as an independent expert. And I'm going to use that term hired kind of loosely because, I understand sometimes they are also just appointed by the courts, and you may or may not have any say in who is appointed. If you do have some say in that, if you do have the opportunity to weigh in your opinion, talk about it with your lawyer. Go for the person who is not necessarily the cheapest. I know a lot of people make decisions based on cost. This isn't necessarily the time to do that. Go for the person with experience. Go for the person that has a relationship with your lawyer. Go for the one that you can trust, really, that's going to do the job that they are being appointed or hired to do. And remember that they are this independent expert. And the custodial evaluator will be meeting with you, will be meeting with your spouse or your, co-parent, and will be meeting with the children and will be conducting an investigation, much like, what I already kind of outlined that the attorney for the child can do. Custodial evaluators, they can do the same thing. They can review school records, medical records, text messages, emails. They can talk to witnesses, collateral sources, therapists, you name it, they can do it. They can run you through psychological tests, all sorts of things. And most often they are mental health professionals, social workers, psychologists, psychiatrists that perform these evaluations. So have the same conversation with your lawyer before you meet with the evaluator, just like I suggested, and before you meet with the attorney for the child or the law guardian. It's very, very, very important to have that and for your lawyer to know what information you're conveying to the evaluator, okay? And remember that when you are meeting with these people, they're not your friends. They're not your friends. They're not your counselor. They're not your therapist. And I especially want to caution you in these beliefs when it comes time to meet with a custodial evaluator, because a lot of people do start to confuse that. And I don't know if it's just a function of the way the interviews are performed, because as I said, a lot of times these people are, in fact, mental health professionals. So that's sort of the flow of the conversation. And it can feel in the moment that you're there very much like counseling or very much like therapy. But remember at all times that it is not. It is not. And no matter how friendly the person is being, how courteous, how cordial, how much you think that they agree with you and are validating what you're saying, don't mistake that for friendship or for, a sign of what their position necessarily is or what their report will read. And that is the other thing you need to remember, especially with the Custodial Evaluator, much like the guardian ad litem. They are preparing a report, a written report for the court. And, the ones that I've seen and been a part of and reviewed are very lengthy, extremely lengthy. They include verbatim statements that a parent has said. They include very descriptive summaries of interviews, of a child's reaction when they're with a parent, other gestures, anything that kind of shows your emotions or your feeling state. They also reveal test results, okay? So remember that they are preparing a report that will be reviewed by the judge. So be mindful of your words. Be very, very mindful of your words when you are meeting with the evaluator. And wow, time really flew by fast here today. Before you go into these meetings, you would do yourself a favor to prepare yourself. Okay, prepare yourself mentally, physically, emotionally. All three levels, prepare yourself. Obviously, you're going to show up on time. You're going to dress appropriately. You might even want to treat it like a job interview, okay, when you're meeting with these people. So be on time. Have your notes ready. Think about your questions in advance. Have them written down. It's okay to ask questions when you're there, meeting with them. Obviously, dress for the part. Dress like it's a job interview. Treat the person with respect. If you can't make the appointment, if you're running late, call to cancel, call to reschedule, okay? If you're given homework to do, things that you need to follow up with, please don't let that go. Do the follow-up work, show that you're interested. So that's how you can really show up and be prepared. Bring with you and know things like where your children go to school, who their doctor is, who their dentist is. Bring that stuff with you. Either have it written out in a summary form. Maybe that's something you can give to the person, or at least have it in your head. But you're going to want to definitely know the basics. Have that stuff with you, okay? And I think at the top of the next episode, I'm going to give you a bunch more pointers here on how to actually have these conversations and how to continue in your preparation. So it's more, obviously, because it's more than just showing up physically, right? But that's one place to start. Show up physically, treat it like a job interview, okay? So thank you for joining me. There's a lot that I didn't really address, but hey, I'm going to do it in the next episode since that's why we're keeping to the themes here. If you enjoyed what you heard, please leave me a review in iTunes. It means a lot. It helps other people find the show. And let's connect in the Facebook group if you have any questions. Take care. Thank you so much for joining me today. Come back next week and be sure to visit my website at dpremalaw.com to book a call, or let's connect on Facebook at dpremalaw, where you can join my group for more support. Please remember that the information shared is for general and entertainment purposes only, and that by calling in or messaging me, we are not creating an attorney-client relationship, and my advice is not intended to be legal advice. For specific legal advice, please contact a lawyer in your jurisdiction.
This show is brought to you by InflowRadio.com, the best curated talk radio network for personal development, wellness, spirituality, and conscious business.